Hello everyone, we are Group 8, and today we're going to talk about Loving versus Virginia, and the case is from Volume 388 of U.S. Reports, and it starts from page 1, and the case was decided in 1967.
The fact of this case is that Richard Loving, a white man, and Mildred Jeter, an African-American woman, were married in 1958 in the District of Columbia. After their wedding, they moved back to Virginia and was arrested by the sheriff for violating Virginia's anti-miscegenation law, which deemed interracial marriages a felony. The Lovins pleaded guilty and were sentenced to 1 year in prison, but suspended the sentence on the condition that they would leave Virginia and not return for a period of 25 years. In 1963, they filed a motion in state court to vacate the earlier judgment and sentence as being in violation of the 14th Amendment. Since the original judge refused the requirement, the case eventually made its way to the United States Supreme Court in 1967. The Supreme Court announced its ruling in Loving versus Virginia in 1967. In an unanimous decision, the justice found that Virginia's interracial marriage law violated the 14th Amendment to the Constitution.
And the issue is, does Virginia's statute prohibiting marriages between persons solely on the basis of race violate the Equal Protection and Due Process Clause of the 14th Amendment? And the holding is yes.
Now I'm going to introduce rule of law due process. The Fifth and 14th Amendments to the United States Constitution each contain a due process clause. Fifth Amendment is for federal, and 14th Amendment is for state. Due process deals with the administration of justice, and thus the due process clause acts as a safeguard from arbitrary denial of life, liberty, or property by the government outside the section of law. Now I'm going to introduce Equal Protection Clause. The Equal Protection Clause of the 14th Amendment of the United States Constitution prohibits states from denying any person within its jurisdiction the equal protection of the laws. In other words, the laws of the state must treat an individual in the same manner as others in similar conditions and circumstances. The Supreme Court has different levels on determining if a law has infringed upon the rights of an individual under the 14th Amendment. To pass strict scrutiny, the legislature must have passed a law to further a compelling governmental interest, and must have narrowly tailored the law to achieve that interest. For a law to pass strict scrutiny, the legislature must have a compelling state interest that is done through the least restrictive means. Examples of compelling state interests include national security and fighting racial discrimination. Even if there is a compelling state interest, the government must prove that the law is the least restrictive way to achieve the interest. Classes that fall under strict scrutiny include race, national origin, religion. About intermediate scrutiny, unlike strict scrutiny, a classification that falls under intermediate scrutiny has a lower overall to justify a law that affects a class. The law must have an important rather than compelling state interest, and must be substantially related to achieving the interest. Gender is a well-known classification that falls under intermediate scrutiny protection. The last scrutiny is rational basis. The lowest standard for a law to pass under an equal protection challenge is a rational basis test. A law must have only a legitimate interest and let the law rationally undertake the interest. Classifications that fall under this state include mentally challenged people and so on.
Reasoning state court. According to issue, the state court contends that because of its miscegenation, statutes punish equally both the white and the Negro participants in an interracial marriage. This statute does not constitute an invidious discrimination based upon race.
Now I'm going to talk about the reasoning by Supreme Court. First, Virginia prohibits only interracial marriage involving white persons. For example, if an Asian and another Asian get married in the state, they would not be punished by the law. This measure is decided to maintain white supremacy, violating the equal protection. Second, classification involving race and ethnicity receives strict scrutiny rather than rational basis. Third, marriage is one of basic civil rights of man, fundamental to our very existence and survival. The marriage restricted by individuals' racial discriminations deprive all the state's citizens of liberty without due process law.
The conclusion: the Virginia Supreme Court of Appeal decision and the Lovin's conviction are reserved.